This second session of our International Grand Committee meeting to a start. Thank you, Elizabeth Denham, for joining us, and to Steve Wood as well from the Information Commissioner's Office. I know, Elizabeth, you've given evidence to our committee and to the Canadian committee before. This is the first time you've probably done it in the same room at the same time, but hopefully we can make good use of that. I know that the colleagues have questions both about your work here in the UK and your recent report to the committee and to the House, and I know our colleagues from Canada and Singapore have questions for you as well. If I could start off with Ian Lucas.
Hello again. When we last spoke, we had a conversation about when a data breach happens, and I think you mentioned that the law had changed recently in the UK to there being more obligations on businesses to report data breaches than there were previously. So before, in the old scenario, I think before the legislation earlier this year, did you receive data breach reports from businesses on a periodic basis from time to time?
We did receive data breach notices from especially the health sector in the United Kingdom, and we would receive voluntary notices of significant breaches as a good practice. But there wasn't a legal requirement to notify our office of significant breaches until May 25th of this year.
Did you ever receive any reports of data breaches from commercial organisations rather than, say, hospitals or anything like that, on a voluntary basis?
Yes, we did, particularly from financial services, from banks and other financial services organizations would advise us of breaches, especially when a large number of consumers were affected by a breach.
Do you know whether you ever received a report of a data breach from Facebook?
Over the history. I'm not aware of any breach notice that we had received, particularly from a technology company, but not from Facebook. But now, under the General Data Protection Regulation, there is a requirement for all companies to report significant breaches, as well as public bodies.
Now, when we last met, I asked you a question about the GSR breach in 2015, and I asked you about who knew about the data breach within Facebook, and you replied in your written. Thank you very much for your written response, which I'm going to read out. Actually, the particular sentence I'm going to ask you about. You say, "We do not hold evidence that Mark Zuckerberg was aware of concerns about GSR in 2015. However, that isn't to say that he wasn't aware." And I found that quite an interesting response. I spoke to Facebook this morning, along with my colleagues, and they suggested that Mr. Zuckerberg first knew about this in 2018. Have you any information that he knew before then?
We have searched the records that we've received from Facebook through our information notices throughout the investigation. We've issued 3 information notices to Facebook for various evidence. We know that there's a long chain of recipients to email that shows that people knew about the breach, but we do not have Mr. Zuckerberg's email on those documents. That's not to say that he didn't know. That I can't theorize about that, but obviously senior people in the organization were aware of that breach in 2014, 2015.
So that's in the United States?
It's in the United States. Our focus of our investigation is really about holding the corporation, the organization, accountable for data breaches, for contraventions of the law. So we're not focusing on individuals, we're focusing on the corporation.
I asked Facebook this morning about their business model, and I have concerns about the way that developers seem to be sharing information with Facebook. almost as a matter of course. I mean, I asked for a single example of a case where Facebook had withdrawn services to a business because of a breach, and they couldn't provide me with one. Does that surprise you?
I was following the evidence, Mr. Allen, this morning, and earlier this year in 2018, Facebook did report that 200 apps had been suspended from the platform, and they had carried out some investigations. I think some apps were then allowed back on the platform, but our office has been following and investigating and looking at various apps that were associated with the Psychometric Center at Cambridge University. So we've been following the data on some of those issues, but of course our office can't investigate every app on the platform. We're really focusing on political campaigning and the apps associated with the GSR breach and the Psychometric Center.
So when you say 200 were suspended, when was that? Was that recently?
It was over the summer, so after the revelations.
Yeah, because after the revelations, they said they were going to carry out an audit, didn't they, at that time? So you are not aware of any case before the revelations?
I am not aware of any case before the revelations, but I'm just reporting back what Facebook has told us in the summer of 2018 when there was a suspension of 200 apps. And what happened after that is a question for Facebook.
So they haven't provided you with any case?
No, as I say, we are looking at some applications associated with the Psychometric Center.
Thank you. Clive Efford.
Yeah, just to follow on my colleagues' questions on GSR. Evidence that we've seen suggests that Facebook is very much is run by one person at the top, which is Mr. Zuckerberg. So given that what you've said in your response to us, that people in the policy team at FB were aware, as well as Facebook's external counsel, in your investigations, would you say it's unlikely that Mr. Zuckerberg wouldn't know? Did you discover that the way that the company was run was similar to what I've just suggested, and therefore makes it very likely that he did know what was going on?
I can't say whether he knew what was going on. I can say that in our experience, it has been important that we are able to connect with senior officials in the U.S. at headquarters, and that's the way that we were able to move forward in a more timely way with our investigation. So I was able to speak with and connect with the Chief Operating Officer, Ms. Sandberg, and that helped our investigation.
I'll leave it there.
Thank you. Charlie Angus.
Thank you. Well, it's a real pleasure to be here in the UK with you, Ms. Denham. You used to come to the committee back in Canada when you were the acting representative on privacy issues. So I'd like to begin by talking about the Canadian perspective on this, which is Christopher Wylie, Zach Massingham, Jeff Sylvester, and the Canadian connection to the Cambridge Analytica scandal. One of the things that was really striking about what Christopher Wylie said was that how SCL found it convenient to have to set up a number of players in different jurisdictions. It was easier for a number of reasons for them to run these campaigns. And what we found out when we began our investigation, looking into originally the breach, was that we had two guys above an optometrist shop in Victoria who suddenly came into all this money and may have undermined the Brexit vote, but were beyond the jurisdiction of Britain because they were in Canada. And then we, subpoenaed them and forced production of documents. But it raises to me the question of the adequacy of tools for dealing with data mercenaries who are set up outside of jurisdictions where they operate. And if you can give us any specifics that you think we should address or anything that we may have missed, because we're still, despite the best efforts of our Parliament, and I do think we are willing to could go into the corners with these guys, but we still couldn't get straight answers from Aggregate IQ at the end of the day about their corporate structure, about how they were set up with SCL, and we can only go so far. So what are the tools that we need to have to be able to constrain or to hold to account data mercenaries who are outside the jurisdictions in which they're operating?
I think with digital campaigning, with big data politics, with big data commerce, and the fact that personal data is really the asset that's driving the internet, it's extremely important that data protection regulators have the ability to reach beyond their borders, extraterritorial reach, as we have now in the UK, in the EU. We're able to follow the data in that way. But it's also very, very important that we have strong enforcement powers. We have powers to be able to compel documentation, to be able to reach into the cloud beyond in a digital search. That's very important. And during this investigation, which is probably the largest data protection investigation that we've ever undertaken, certainly in Europe, we were able to seize documents and evidence. We were able to have 700 terabytes of data from Cambridge Analytica that we're crunching through, forensically examining. But we were also able to work with our colleagues in other jurisdictions. Our Canadian colleagues were also collaborating with law enforcement agencies in the US and the UK and beyond. So I think what's really important, there's 9 jurisdictions in this room, all concerned about protecting personal data, especially in the context of elections, campaigns, and referenda, but even beyond that. And it means that we have to be able to have the tools to work together, to collaborate and cooperate, because this is truly a global issue. So that's a strong recommendation.
Just to add a little bit to what the Commission said there as well, I think it's really important that international regulatory cooperation networks are strengthened. So around the world, we're still observing that data protection authorities can perhaps have quite weak or limited powers which give them the legal basis to cooperate and share information with their counterparts internationally. And longer term, we probably need to look at things like multilateral treaties. We really have quite some strong reciprocal enforcement mechanisms there to really make the extraterritorial scope of our laws as they change work in practice. We're still at a relatively early stage really as data protection regulators in learning to cooperate around the world, because data has no borders now. This is a really urgent task in terms of doing that. From the UK perspective, we're now chairing the International Conference of Data Protection Commissioners to try and lead that work, to try to get some more global solutions, but it's going to take time. Lots of different countries need to join this work.
Thank you. Well, I have 2 more questions on that, which has to do with the need to ensure that our regulators have the tools and the teeth. I think it was 2008 or 2009 when you were the Canadian Acting Privacy Commissioner. You launched what I understand is the first investigation into Facebook on their loosey-goosey approach to privacy controls, which I believe if they had followed your findings and your rulings, we would never have had the Cambridge Analytica scandal. That was 10 years ago. You didn't have the order-making powers to make them comply, but even if you did, it seems that Facebook has a sense that laws are something that they will consider if it works, and if it doesn't, they will find a way to explain it away or ignore it. In light of what we've dealt with now, you were very prescient back then. Do you think that we could have avoided a lot of this stuff if Facebook had shown some corporate responsibility back when you issued your report?
Well, that was, as you reminded me, 10 years ago that the report was issued by the Canadian Privacy Commissioner's Office. And that report laid bare the business model of Facebook and explained how the advertising model worked, how third-party applications worked, the openness of the sharing of data with friends and friends of friends. But at that time, and still today, the Federal Privacy Commissioner in Canada doesn't have order-making power, doesn't have enforcement power. Any finding has to be enforced by federal court. And I feel that Facebook has looked at the Canadian finding and the Canadian recommendations, as well as the Irish recommendations as more like advice. And the message I heard from Facebook this morning is, unless there is a legal order compelling a change in their business model, a change in their practice, then they're not going to do it. And that's a serious statement, but that means that we have to have strong laws and we have to have enforcement tools to move online platforms in the right direction so that they take people with them in the services that they offer.
Well, and then I'm going to close on this, because when you were in Canada, you didn't have the order-making powers. You do now have the order-making powers. You've issued a substantial fine against Facebook. Perhaps I didn't hear Mr. Allen correctly, but it seems that your findings of 2009 he still feels is advisory, because it's on Principle 1 about the platform that was constructed to harvest data of friends without consent. He says that it's all there in the terms of service agreement, and he said that this morning. So is Facebook telling us that they believe that they can write terms of service agreements that override the laws of many different countries? Because that, to me, is very disturbing. Are you finding that in the appeal that Facebook is making that they're misrepresenting your findings publicly? Because I would find that very disturbing. If we're going to have corporate accountability, if we still see this culture of a corporate immaturity, that they don't think that they need to be truthful, or do you feel that they're being accurate in how they represent their challenge to you? And do you think that they respect the necessity to respect the law about these issues of consent?
So after a 9-month investigation, we issued a fine in October of this year. It was the maximum fine that was available to us under the previous regime, and I stand by the findings and the enforcement action by my office. That said, any organization, any company has the right of appeal. But I was really disappointed by Facebook's statement in the context of the appeal, because I do think that they misrepresented the fact of our finding and the rationale for issuing that fine. So the statement that Facebook published last week said that our investigation found no evidence to suggest that the information of Facebook's 1 million UK users was ever shared between Dr. Kogan and Cambridge Analytica or used by affiliates in the Brexit referendum. So that was in Facebook's statement. And that much is correct about our investigation. But our fine wasn't about whether or not UK users was shared in this way. We fined Facebook because it allowed application and application developers to harvest the personal information of its customers who had not given their informed consent. So think of friends and friends of friends. And then Facebook failed to keep the information safe. So in UK terms, that's Principle 1 and Principle 7 breaches. And that's pretty basic data protection 101. That's about notice and transparency and control. It's not a case of no harm, no foul. Companies are responsible to proactively protect the personal information, and that's been the case in the UK for 30 years. So Dr. Kogan and Cambridge Analytica is just one example of what Facebook allowed to happen. And what we're talking about here is up to 87 million Facebook users' data represented in the jurisdictions of those of you around the table. So Facebook broke data protection law, and it's disingenuous for Facebook to compare that to email forwarding, because that's not what it's about. It's about the release of users' profile information without their knowledge and consent. That's messages and likes. That's their profile. So I guess at the end of the day, I'm really disappointed that one of the most innovative companies in the world, because great things happen on Facebook, have not replicated their innovation in ways that protect people's privacy online. That's how I would summarize it, Mr. Angus.
Great, thank you. Nathan Erskine-Smith.
Thanks so much. I want to pick up on Charlie's line of questioning there talk about the interpretation of the law, because I was a bit confused. It's apparent to me that Mr. Allen's not a lawyer, because he said to us today that for someone to have signed up for Facebook and agreed to the terms of service, to have not gone into their settings and to have checked a box to ensure that their information was had additional privacy protections, those one step and one omission together meant that there would be meaningful consent for their friends to share, for my friend to share my information with any app developer, regardless of purpose. That seems to me to be contrary to any notion of meaningful consent. What do you think about that?
Well, I think that's the basis of our fine. So we found that there wasn't consent, there wasn't meaningful information, there wasn't meaningful notice, and terms of service can't trump the law.
Well, you said it's sort of a privacy law 101. Facebook is worth billions and billions of dollars and can surely hire a lawyer. A lawyer wasn't here before us today, but why do you think it is that they're still challenging a ruling when the basic premise of meaningful consent is so very obvious to any lawyer who's ever practiced privacy law?
Because the profiling and the use of personal information, complying with meaningful consent and notice, is a tension with their business model. But I think there's a way to resolve this, but regulators need to enforce the law. I need to do my job, and that's what I'm doing here. And Facebook has the right of appeal, but I think they shouldn't misrepresent our findings and the basis of our monetary penalty.
And from a legislator's point of view, when one is frustrated with the lack of accountability, and certainly what seems to me to be Facebook officials coming to the table and apologizing only after they have been found out to have made a series of mistakes. It's frustrating and bizarre, I think, also, that they continue to compound those mistakes and to say, we're sorry, but oh, by the way, we did nothing wrong. It's strange. So with respect to penalties, so in the Canadian context, our Federal Privacy Commissioner does not have the power to make orders, does not have the power to levy fines. I've actually introduced a bill in Parliament to address that, but you have now powers under the GDPR to levy significant fines. Facebook, I was on a panel recently with the head of public policy for Facebook Canada who said, well, naming and shaming works just fine, and the Ombuds role has served us well. And your view of the Ombuds role versus having significant powers, do you think companies like Facebook are responsive to naming and shaming, or do you think the power to levy fines is of critical importance?
I think you need the whole package. So you have to have the ability to issue orders, maybe a stop processing order, telling a company they can no longer process personal information for a certain purpose and in a certain way. That's pretty powerful. But having the fines available is a way, I think, to focus attention at the board level of an organization and really build good data governance.
Thank you. Joe Stevens.
I just want to go back to a question that I asked you when you came to see us on the 6th of November, if I could. It was about illegal data sharing between Aaron Banks' Eldon Insurance and the Leave.eu campaign, when in September 2015, Eldon Insurance sent over 300,000 emails to newsletters, Leave.eu newsletters, to Eldon Insurance customers. Now, you issued an information notice to Eldon Insurance in April 2018, and Eldon Insurance told you that they themselves had reported that breach to you. And I asked you, I think in November, when they reported that breach. Can you tell us whether or not you have found out from them when they reported that breach, and have you had any proof of that, please?
Eldon Insurance stated in response to our information notice, as you said, that they reported that breach to us when information was shared between both Leaving EU and Eldon Insurance, and we found no evidence of their report of such a breach. So, and you know that we've issued fines under the PECR regulation against Eldon Insurance, and we continue to investigate data protection issues, and we have announced an audit of Eldon Insurance as well.
And they haven't subsequently provided any proof to you to back up their claim that they...
They have not.
Right. Thank you very much.
Thank you. Bob Zimmer.
Yeah, thanks again, Ms. Denham, for speaking to committee the second time, first time on this side of the Atlantic. I guess just one question I have for you. We're tasked with making laws to really get a handle on Facebook and the social media platforms, etc. And I guess I would just look to your advice. What would you do if you were in our place? If you, and I know it's difficult in your role to say so, but as much as you can say, where would you start with these guys, and how would you best? I think from my perspective, the democracy's at risk is my most important in terms of my view, my concern. How would you best combat that, and what kind of laws would you make? This could be a 2,000-hour conversation, but I'm trying to say it in as brief as an answer as you can give. Where would you start?
Well, one of the reasons that we launched the investigation in 2017 was to look at the whole political campaigning ecosystem, and who are the players in that system, how is data collected and used, and what are the responsibilities of each of those various actors. So political parties are part of this. Political parties have a lot of data. They purchase data, perhaps from data brokers. They collect it in various ways. So we need to look at political parties as part of this as well, and make sure that they're able to use new digital campaigning techniques to engage voters, and at the same time, obviously, comply with the law and be transparent and give people control about how they use information. So this isn't just about social media companies.
Right.
They're a large part of digital campaigning now, and the spend that political parties and campaigns put towards digital campaigning is growing. But before the train leaves the station, and even more intrusive techniques are used in our democratic processes, we have to get a handle on this. So electoral laws, I think, need to be strengthened and brought into the digital age. So election financing, all the transparency and imprints in advertising on platforms. This isn't a simple answer, but we need to look at all of the existing regulations, make sure they're up to date and fit for purpose, but also I think a code of practice for political parties and campaigns, because they're at the center of using these services. And that's one of the main recommendations that our office has made in this investigation, is for a statutory code of conduct for the use of data in political campaigns. That's important, and that might be something that's, as we develop this code, that might be of interest to other jurisdictions.
So the part B to that question then, because we've seen political parties, and we had political parties just appear at our committee in Canada to answer questions, but I think for the most part, political parties follow the rules. It's in their best interest to do so and follow the framework as best they can. Again, it's in their best interest to do so. My main concern, although that is part of it, my main concern is the foreign actors and the people that show up with a Facebook account that's started 1 week and is actively campaigning against members of Parliament sitting around this room here for whatever reason. How do we best get a handle on that? The outside the official establishment, how do we get to those bad actors?
In terms of that, the context of, I guess, of different actors coming into the political space and just not the main parties, I think the proposals we've seen around better registration systems for how political adverts are to be organised online, and then the transparency which follows from that, so you can actually see who's targeted that advert and who's paid for it. I think the challenge is to make that work in practice, and it's certainly something we know the Electoral Commission are taking a strong interest in the UK. We've seen Facebook have rolled out this initial programme in the UK. We've certainly seen some evidence, but it's been circumvented already in some circumstances. So I think we've got to learn as well how to make this work in practice. So it's good to see some proposals coming forward about making this work, but particularly for those actors who perhaps may have an interest in not being transparent about who they are in terms of using the advertising systems on social media platforms. We've really got to focus on some quite strong governance, which really gets people to engage with a process of identifying who they are, so that transparency works in practice, so that you can follow the money, see the ads. So I think it's a good principle, and we're supportive of it, and we made a recommendation around that area that it should go forward in our report in July. I think we've got to learn from the practice and see how it's working. It's obviously been rolled out in other countries as well, so we look forward to seeing how that works.
Thank you.
Thank you. Charles Watling.
Yes, thank you, Chair. I'd like to move on to the regulation. We touched on it earlier. You said in your excellent response to us, Ms Denham, that you acknowledged that without a very substantial injection of resources and headcount, that it's unlikely that any regulator would be able to directly handle the volume of individual complaints and so on. I'd just like to ask you, do you mean by that, whatever regulations we might like to put in place, that it's almost unenforceable?
Not at all. So my response around internet harms was not necessarily just in the political context. It was about regulating content and conduct online. And my point was that if you set up a regulator to take complaints about takedown requests where somebody saw offensive material online and wanted it taken down and went to a regulator with every single complaint, then you would have a regulator dealing with millions of complaints. Yeah. So rather than that system, I think what's an opportunity to think about is regulating the effectiveness of processes that have to be put in place for things like taking down or responding to complaints from individuals. So the regulator is saying, are all of the processes effective for meeting the public goals and the objectives that are set out by Parliament? So you come up with a standard, and the regulator has to go into Facebook, Twitter, Snap, Google, and say, show me how effective you are, and be transparent about the numbers of takedowns, the context of the material, because we're talking about something that could have potentially millions and millions of complaints.
So what you're saying is you're relying on the companies themselves to do that work.
But you have a regulator as a backstop that's ensuring that they are meeting standards that are set in law. Right. And that's what we don't have right now. The gap in internet harms is we don't have anybody who is regulating content and conduct online. We're regulating the use of personal data. We're not looking deeply into content.
So that's what you would recommend that we do, and that's what you'd recommend we do on a global basis?
I think that's where the public concern is. The public is really concerned about what happens online and the kind of harms online, and they expect their parliaments to regulate, to protect them from those harms.
Thank you.
Thank you very much. Soon Su-Ling. Okay, fine. Evan Tom.
Ms. Denham, good afternoon. Thank you very much for being here and also for your note which you've sent to the committee before today. I have a couple of questions that arise from what you've said here. And one of the points you made at, I'm not sure which page this is on, but in the, I think, second full page of the note, you say that a coordinated approach needs to be taken to internet harms. By that, I take it you mean that not only do we need regulation and legislation like you spoke about a short while ago, but also a range of other measures such as media literacy, improving standards of journalism, for instance, making sure that the schools teach our children the right approach to being more discerning on the online and so on. Would I be correct?
I think addressing the kind of harms that the public is concerned about, everything from misinformation to disinformation to opaque advertising in the political arena, to kids spending too much time online. All of these issues, data privacy as well. It's complicated to say how are we going to address this.
Yes.
But I think digital literacy and digital media is really, really important, and that makes us all a little bit more diligent in how we read things online, understand them. But we also need transparency. We need more regulation. There's so many different aspects to this.
Yes.
And when you look at the political context, which has been the focus of our investigation, we have some very specific recommendations.
I understand. So what you're saying is that there's no single silver bullet, but there's got to be a suite of measures to tackle this problem.
You said it very well, and I think there are many actors in this space, from companies to citizens to the education system to the social media companies to Parliament.
Right. Now, on discussion of legislation, you mentioned in your report that there are still a number of internet harms which do not appear to be fully addressed by existing law and regulation. And you go on to cite the fact that online harm, which may be currently legal, online harmful conduct which may be legal, needs to be dealt with. Can you elaborate on that?
So, obviously, countries have defined what is illegal online, and the issue there is how is that enforced? How quickly do social media companies and online platforms remove and deal with illegal content? But the gap is actually in content which is legal but may be offensive to certain individuals. Kids, that's a good example. And that's where I think the public is looking for legislators to find the right regulatory approach that deals with the online harm, but also protects freedom of expression, protects innovation, and balances those processes.
Yes. So to protect, say, children from, well, not just children, but the general public from content that could be seditious, for example, or that could be insightful of hatred conduct, would be something that you would look at and
I think
seek
so.
regulation to protect general public against. Would that be right?
That's correct. And although it's complicated and it's complex to come up with the rules that are going to balance all of these interests, it feels, and our research shows, that that's what the public expects parliaments and legislators to do.
So the sense is that some kind of legislation needs to be enacted to deal with those online harms, define what those parameters might be, and again, to borrow your language, you say here also that online non-criminal harms could be as significant as criminal harms because of the scale of the potential activities. And by that, I think you mean the proliferation of material on the internet and quick speed and spread of such material on the internet. Would that be right?
That's exactly right, and we're especially concerned when it comes to children and vulnerable adults.
Right.
Did you want to add to that?
Just to add really about preparing to think about legislating this area, I think it's probably the biggest gap because it's the most complex area because it's the intersection with freedom of expression, and the public have a wide spectrum of views about what they might find upsetting or information they think should be removed. And I think we've got to learn how to have quite deep dialogue with the public. We've got to come up with ways of research, probably concepts like citizens' juries, to really come up with some sophisticated ways to balance these issues to get the decisions right. And I think the issues about harms which may build over time, may have an impact on people's mental health, etc.
Yes.
Those issues we've got to factor in the longer term effects of various internet harms. We've got to learn and have all of the evidence and research to back up that approach to take.
So those objectives has got to be balanced with the speed at which you can address the harms being spread. So one needs, I would imagine, strong levers, quick levers in order to stop and stem the tide of the spread. You would also need to be very clear as to what kind of information society to society may differ. And so I think each parliament has to be looking at it from the perspective of what society needs to be protected against.
I think certainly from the perspective of the public, when they see something concerning, upsetting, they expect something to happen fairly quickly. So you're right, I think we've got to learn how the levers can work in practice from the companies responding, and also what the checks are from the regulator, to look at the overall systems they're using, if those need to be adjusted, if the criteria they're using are not right. That overall system approach has to be adjusted quickly to reflect concerns as well.
Right. Thank you.
Thank you. Julian Knight.
Thank you, Chair. Mr. Dunn, you've been, during the course of the inquiry, you've been very helpful to this committee. You've been very open, both in public and private. First of all, I'd like to thank your organisation for the way in which it's interacted with the committee. But I do have just a few questions I really want to put to you. I mean, a £500,000 fine for Facebook. I mean, that's probably its sandwich bill for a week. This is almost the definition of a drop in the ocean. What more can you do? Does it actually need to be something that's really fundamental, that really hits them very, very hard indeed in the pocket? The sorts of super fine that we've seen from the EU in the past over American institutions. Do you feel somehow frustrated about the level of fines you're able to issue? What are your thoughts in terms of that fact about the fines that you're issuing?
The £500,000 fine that we issued against Facebook was the maximum fine available to us in the previous regime. So because the contraventions happened before May 25th, 2018, £500,000 was the maximum. And I've been clear that had the maximum fines been available under the GDPR available to us now, we would have issued a much more significant fine to Facebook.
So would you have issued the maximum fine?
A much more significant fine.
Right.
But it's a bit hypothetical because that wasn't available to us. So we now have up to 4% of global turnover, as do the other EU data protection regulators, and that's a significant fine for a company, and it would have an impact on the bottom line of that company. But I also think that our findings and our fine that we have issued is important, because we have found their business practices and and the way applications interact with data on the platform to have contravened data protection law, and that's a big statement and a big finding.
Yeah. So are you looking at Facebook right now in terms of potential contraventions after the new regime came in?
We are, and as you know, with the GDPR, the new legal arrangements are that it's the Irish Data Protection Commissioner that is responsible, as the lead authority for Facebook, because Facebook Europe is based in Ireland. So we are working with our Irish colleagues. We have referred matters of an ongoing nature, concerns that we have in Facebook right now. We've referred those on to our Irish colleagues, and as a competent authority, we are available to help them with that.
Given Ireland's record with firms locating there in order basically to avoid tax, do you think they're going to be as firm as they ought to be in terms of pursuing Facebook and ensuring that these potentially current transgressions are properly punished in a way that the public actually has confidence in?
There are several investigations ongoing under the lead of the Irish Data Protection Commissioner, who I have great confidence in, as well as our other regulators in the EU. So we have joined together in a social media working group because there are so many issues when it comes to some of these tech giants.
Yeah. It doesn't look to me, though, as if, frankly, with this issue of Ireland having the competency on this, it doesn't look to me, frankly, as if the sort of promise that the new regime has in terms of really punishing these firms when they do transgress in this way. It doesn't seem to me, frankly, at this point, as if it doesn't have a great deal of teeth because of that issue of Ireland being in charge of the process, rather than, for example, you going in there and saying, hang on a minute, you're trading in the UK, and therefore you should be facing maximum fines if you are transgressing.
I mean, certainly we've observed closely how the Irish Commissioner's Office has also increased its resources over the last few years to prepare for GDPR. They've over doubled the staff, they're hiring technologists, they're getting ready for this challenge. I think the other thing, just to build on what the Commissioner talked about, if the Irish Data Protection Authority have a case which affects data subjects, people across Europe, then they have to prepare would probably have to prepare a draft decision in that situation. It could then be essentially called into the European system as part of the mechanisms under GDPR. And an overall decision, if the other European data protection authorities, for example, don't agree with that draft decision put forward by the Irish in that instance. So there can be a European-wide decision as part of the mechanism. So there's some balances and checks to make sure it's addressed the concerns of the Europeans.
Can you recommend, though, that they have yet find the maximum amount?
That would be part of the discussion. Will be has the GDPR been applied correctly in that situation?
Thank you, Chair.
Thank you.
You have mentioned that regulation should be a backstop to regulate content and conduct. Would you agree then that there is a need for a framework to bind tech companies, regulators to collectively address disinformation and online falsehoods?
A collective action between regulators and companies?
A framework to bind tech companies and regulators together.
So I believe that the time for self-regulation in this context is over. And my recommendation to the committee for consideration is that because of the public concern of these internet harms around content and conduct online, that Parliament needs to define the outcomes. There needs to be a set of standards that are agreed, and a regulator has to be equipped with the right powers to be able to review the activities of the companies. The complexities of the different platforms is something to take into account. So Snap is different and has different operating processes to Facebook, to Google. That's why I think the platforms have to have some overall standards they have to comply with, but they have to be judged in the context of who they're serving. So a platform that's operating and serving kids, for example, there would be some different requirements. But just to be clear, I'm not advocating for a self-regulatory model. I'm advocating for a strong regulatory backdrop to a set of standards.
Thank you.
Thank you. Pritan Singh.
Good afternoon. The realm of fake news and disinformation is not just the domain of opaque social media companies. In this social media age marked by technological innovation, it can be argued that opaque governments precipitate the formation of a vacuum which is then filled by or abused by peddlers of disinformation and fake news. Given your experience, what advice would you give governments in general and opaque governments in particular around the world that seek to move in the direction of open government? And closely associated, I might as well put both questions together. How does open government better inoculate a citizenry against disinformation and fake news?
That's a question we're quite happy to answer as well, because the other piece of legislation we're responsible for as a regulator is the Freedom of Information Act in the UK. And I think government setting the example of putting as much factual information into the public domain to support and inform debate, so that provides a rich seam of information which can support debate, and government showing the way by being open and proactively responding to freedom of information requests that citizens may make, and that also being part of a fact-checking process. That's probably another part of the jigsaw which I think can set an important standard. I think as we've discussed already today, it's another lever which can help improve the environment, and I think if government is legislating in this area, a good way for government to set the standard is showing how it's being open itself. I also think that means embracing new technologies about open data, very much explaining how data can be used to understand the workings of government and making that available to civil society, etc. So I think certainly it can have a role to play in that wider debate, but it's one part of the jigsaw.
You spoke about fact-checking. I think it's one of the recommendations actually that our select committee in Singapore actually looked into. Of course, it's not so simple because there are other questions about who finances it, who funds it, and questions of that nature. If you have the government funding it, then of course the question is there an obvious conflict of interest there? What advice would you give for countries which are considering fact-checking platforms, particularly small countries like Singapore, where the media landscape or media companies may not have I wouldn't say deep pockets, because some of our media companies do have deep pockets, but obviously again a conflicted party driving that fact-checking process, because there are contradictions.
I think certainly you're right that it's a balance, because equally you don't want to have a Ministry of Truth and an overarching body which decides all factual bases that people might seek to complain about. I think certainly having a strong regime for the regulation of national statistics, which we have in the UK, is a good basis to start at some core areas where data is particularly quoted as a central area of national debate. Also, I think a strong, vigorous civil society of fact-checking groups, as well as starting, I guess, still to pioneer some ways of how to do that, how to use large data sets as well, because fact-checking can often be complicated with big claims as well. But I guess the UK, like a lot of other countries, is finding its way. But I think at the core has always been a bedrock, I think, of particularly official statistics, and a high degree of confidence in that area is an area the UK has led strongly on in that area.
Thank you. Thank you very
much. Thank you, Nathan.
Just really quick, you had mentioned the need to, or the public's concern is additional regulation perhaps of content. Now, I'd asked Facebook because they supported an act dealing with tackling content and perhaps even legal liability for Facebook if they don't take down content in relation to child exploitation. It seems to me it's a short step to then imposing legal liability for failure to take down hate speech and other obviously and horrible illegal content. That wouldn't be yourself regulating that. That would be some agile judicial oversight of some sort in coordination with whether it be the companies themselves or some other regulator. But you spoke to regulating effectiveness of processes, and you've spoken to transparency, but I haven't heard today anything about algorithmic transparency and auditing algorithms. And I raise this because Richard Allen says something at the end, which I wish we'd explored a little bit more, which is he said where content is right up against the line, and we've deemed it not hateful, so we're not taking it down. In fact, their algorithm has a perverse effect, because it is divisive, because it is designed to get a reaction, their algorithm actually increases traffic for that content, and they are looking at maybe not rewarding this content that is pushing up against the line of hate. That seems obvious for a company to do that if they cared about the public interest. Would the ability to audit algorithms reside in your office? Is that the appropriate place? And speak to the importance of algorithmic transparency and auditing algorithms in a human rights context.
Right. Under the GDPR, there's enhanced requirements for explainability in algorithms in the context of personal data. So if a company or an organization is making a decision that's basically by machines, it has to be explainable, it's challengeable. And another part of the work that we do is we are going to be auditing algorithms for issues of fairness, data protection, bias, all of these issues. So we're going to be in the space of looking at algorithms and looking at transparency. But you're talking now about algorithms used to deliver content. And that's associated with us, but it's not right in our space.
Right.
The challenge is, I think the challenge for all of us is that data protection is horizontal. It runs across digital advertising, digital campaigning. The use of personal data it's part of all of this. But we're not an expert content regulator. But nobody is. So it's whether or not a country, a jurisdiction thinks about sharing the load between existing regulators and finding some kind of a collaboration, or creating another regulator. But you have to be careful that it's not actually crowding out the existing space, because that creates confusion for individuals and confusion for companies.
Right, because it seems to me we have this traditional regulation of content in relation to editors, and we hold editors accountable. And as editors are replaced by algorithms, for some reason we've failed to hold the algorithms accountable and to hold the companies that are making billions of dollars in profit from these algorithms, in part at least. Thanks very much.
Thank you. Bob Zimmer.
Actually, I'm going to pass my time over to Mr. Lucas. I think he can answer it better.
Okay.
Yeah, sorry, we know what, we're not reading each other's minds here.
Just a couple of brief follow-up questions, actually, just on GSR, again, I'm afraid. Firstly, I think you said in your evidence that within Facebook, they were first aware of this in 2014. Is that correct?
I would have to go back and look at the report. Are you...
Because the evidence we've had is that some of the evidence is that in the awareness of within Facebook was because of a news report in December of 2015. That's why I'm asking the question. Are you aware of them having any awareness before 2015?
I would have to write to Mr. Lucas.
That's
because
fine.
I don't have the report in front of me.
That's fine. And also connected with that, you referred to a number of senior managers. I think was the phrase or the wording that was used. Can you name them?
We can write to you with those names. I think what we've written so far is we've described the types of positions and titles.
Yeah. But even those, we're discovering that the Facebook management structure is somewhat Delphic. And I think the best way of us being clear about change of responsibility is to have the names. So if you could write with the names, I'd be very grateful.
I will write.
Thank you.
Thank you. If I could just close with a few questions, I don't think there's any other... oh, sorry, Charlie, yes, you go first.
I just want to follow up on my colleague's question about algorithms, and I ask you because you come from a Canadian context, and we have no digital committee in Parliament. The Ethics Committee, our usual job is smut and corruption, and dodgy lobbying meetings and loopholes, and it's something I understand. I got 52% in grade 10 math. I don't know what an algorithm is, and yet I'm being asked now more and more to say we have to start looking at the ethics of algorithms in terms of public policy. So as much as we look to our regulators to try and understand this, as parliamentarians, we're setting public policy based on how governments will deliver services, how all manner of things will be. I just would like to follow up on my colleague, a suggestion or a recommendation where we need to go in terms of starting to put the issue of ethical accountability for algorithms as a public policy issue that needs to be looked at and we need to keep an eye on, whether it's a standing committee or whether it's a one-off study. What would you recommend?
I think it's a critically important area of study for legislators. In the UK, committees, the House of Lords, Commons committees have been examining the impact of algorithms and AI on society across all sectors. In the public sector, in the private sector, the impact of AI on future employment, on jobs, self-driving cars, robotics. These are really critically important areas. So a standing committee, various studies, absolutely, in Canada, because you have the focus on digital innovation in AI, the public policy that goes along with that and the digital ethics are critically important.
Yes, Rebecca Power.
Do you think that a committee like this, going forward, could be valuable in informing how we are actually going to go about regulation on a worldwide scale? Because it's quite clear to me, talking to all these different countries who are doing a great deal of work individually, that this is much more than an individual country issue and that we do need to align.
I'm really pleased to speak to this committee. We've got 9 jurisdictions here representing 450 million people, looking at issues related to internet harms and electoral interference. These are widespread concerns, issues of widespread concern to your citizens. And I mean, ideally, there would be some kind of international instrument or an international agreement with a set of principles that your democracies could agree to. That's going to be some time away, I suspect, because domestically you have different constitutions, different cultures, different laws. But I think that all of you share some things in common, and we do have these big internet companies that are working in this space and are globally delivering services. So the answer is yes. I think working together is very positive for your citizens. And when one jurisdiction goes out with a new solution, we have France coming forward with their judicial decisions around taking down disinformation. We have Germany's approach. The UK has been very strong in examining these issues and bringing regulators together. The European Commission has the voluntary code. So there's been a lot of initiatives, but getting the jurisdictions together to look at the best approach is very positive.
Okay. Thank you. Elizabeth, if I could ask a few questions in closing this session. When you gave evidence to the committee earlier this month, we talked a little bit about your discovery of Russian IP addresses remotely accessing the data collected from the My Digital Life app, wasn't it? Right. The precursor to the Cambridge Analytica data gathering app. Are you able to tell us any more about those investigations looking at the Russian IP addresses and where they may have come from?
So those IP addresses that resolved to Russia, we have reported and been working with the National Crime Agency on that issue, and it's not one for us to chase down what's going to happen and what has happened at the other end of that, but we continue to work with law enforcement on that. I have no further update than our private session earlier.
Yeah. So would you expect that investigation to be concluded when the NCA completes its investigation and makes takes whatever action it needs to take?
I expect. What I don't know is whether the result of that investigation is going to be shared with parliamentarians. Some parliamentarians. You probably know that process better than I do.
If the National Crime Agency decide there hasn't been criminal activity and decide not to take any further action, would you be able to report in more detail back to the House once the NCA's investigation is completed?
I'll get back to you on that.
Okay.
I need to check with the NCA and the NCSC.
Just following up on Ian Lucas's question about senior executives at Facebook that were aware of the Cambridge Analytica data breach. I appreciate you've got to write to us with names, but from your investigations, do you feel that Facebook has a sort of process in place to notify the senior team of issues like this? Is there a clear reporting path? Are there clearly executives to whom this sort of information is reported, and then it would be expected they may in turn report it to others within the company?
I believe that most of the decisions are made by headquarters. That's been my experience in working with Facebook, and it's certainly, as I said, the way we've been able to move our investigation forward is connecting with headquarters and not necessarily the European representatives, although we're working with them as well.
Yeah.
That's as much as I can say.
So could you say that, would it be fair to assume in that case that when you talk about senior executives at the company who are aware of the data breach, that would be senior executives in Menlo Park rather than just here in the UK or in Europe?
I expect for significant data issues and data breaches that would be the case.
I think we would just expect the situation to have improved since some of those historical events that you're looking at as well. So the requirement under the GDPR is for organisations to appoint a data protection officer when they have a risky profile in terms of the types of data processing they do, and that has to report to board level in organisations. So there are some strong drivers there, particularly looking ahead how internet companies should have the right sort of governance in place for these things to be escalated. So I think it's important to look to the future about what should be done as well.
So, but do you feel, I think from what you said, you can imply from that you don't feel that in 2014, 2015, they necessarily had those structures in place.
I know it has improved. I know it has improved since then.
Yeah.
The company's changed significantly since 2013, 2014, and it's certainly changed since 2008, 2009.
But would it be fair to say that from your investigations, you don't believe that there's a clear reporting structure to board level for data breach issues, data privacy issues?
There is now, and it's legally required, that there is a straight reporting structure all the way to the board level.
But you don't. But you don't think it was then?
I don't think it was in place in 2013, 2014.
But do you think that's extraordinary, given that it was in late 2011 that the Federal Trade Commission ruled against Facebook for a lot of the reasons you set out earlier on, that they weren't protecting users' data and that apps were able to gain as much access to user data as they liked, but seemingly without any restraint. And given that complaint had already been made in 2011 and the company was required by the FTC to put those policies in place, I mean, it does seem quite shocking that potentially 3 years later they still hadn't put those systems in place.
I think that Facebook continues to mature as a company, and I think the pressure that sessions like this and the committee's work and investigations by the FTC, by our office, by Europe, by Ireland, we need to keep that pressure up. And as I said, I'm very disappointed that Facebook, being such an innovative company, couldn't have put more focus, attention, resources into protecting people's data.
Yeah. It just doesn't seem that they took much notice of the FTC's report.
The FTC, as you know, the FTC is having another look at its consent decree, and it'll take some time, but it will be reporting out as well.
Yeah. You said earlier on when talking about users should give informed consent to the use of their data, and you said that with regards to the data gathered by Alexander Kogan for Cambridge Analytica, that this was, your words were just one example. How many examples have you seen of breaches in user data policy?
I mean, we very much obviously focused on that one area in our investigation. Obviously, we mentioned earlier that we heard the news that Facebook had suspended the 200 apps as well. So we're aware it's a widespread problem. We really tried to focus in and narrow in on the areas where we could really make a difference. This is why we focused on Facebook at a platform level to ultimately reach that finding when we've issued the adjudication, which has led to the fine.
Because, but are there any other examples you've investigated?
As the Commissioner mentioned earlier, we've still got ongoing interest in other apps connected to the Psychometric Centre in Cambridge, and that's an ongoing area of interest.
And these are apps that are not currently known about? It's not in the public domain that this is being investigated?
That's right. But in terms of looking at Facebook, we've looked at Facebook in different contexts. We intervened on the merger between WhatsApp and Facebook, because the reason for that merger was increased sharing of data. So we actually worked with WhatsApp and Facebook and have an undertaking by WhatsApp that they will not share information with Facebook until they can show that their plans comply with the GDPR. So we've looked at Facebook in other contexts, but I think your question is really focused on apps.
Because I think one of the concerns we have, and this came up in the questioning earlier, and I think comes out of the papers from 643 the committee's been given, as to actually whether the problem of widespread access to user data, user friend data, without the knowledge of the users was so commonplace that it might not necessarily appear to be a problem to Facebook.
That could be the case, and we're interested in the 643 evidence. We knew about the company, and they were unable to share that information with our office because of the seal by the court. So I am interested. If we are legally able to look at that data, we'll look at that, and that might be important to the litigation that we're going to have with Facebook, because the hearing before the tribunal, there is a potential of new evidence to be submitted in the context of that hearing if it is relevant.
So you believe that the unsealing of that evidence could be important to your current investigation into Facebook?
We don't know what the evidence says,
no.
But it could be, because it could go to decisions that were made in the 2013, 2014, but we haven't seen, obviously we haven't seen the records.
But you said that you had approached 643 yourself to ask whether you could have access to that.
We had a conversation with 643. We talked to their lawyers, but at the time, because of the sealing of the records, they were unable to share the evidence in the email with our office, and this was some months ago.
Yeah. Well, I certainly think that the evidence contained within those sealed documents would be of considerable interest to the Information Commissioner's Office, as it is to us as well. If I could just ask finally, just on Cambridge Analytica, do you believe do you believe that the database collected by Cambridge Analytica, the tools that they acquired, do you believe they're being used by other companies today? Do you believe that they're effectively trading under a different name?
We are actively monitoring the former directors or the directors of the company and any spin-off companies that come out of it. So we are actively monitoring that. We have the ability to follow the data. We're still crunching through 700 terabytes of data, so we are discovering more about Cambridge Analytica as the time goes by. And as you know, we're in court on a criminal matter with Cambridge Analytica in January, so we continue to pursue that.
Yeah. Has the ICO looked into the company Emerdata, which the committee have taken interest in before?
Yes, that's an active line of inquiry.
Okay. In terms of whether Emerdata is being used as the vehicle for Cambridge Analytica? Yeah.
Yes.
Thank you. I think that concludes the questions we have for the session. Once again, Elizabeth Denham and Steve Wood, thank you very much for joining us today.
Thank you.
Thank you. So we now have a final witness who will take the stand now. So that will be Ashkan Soltani, the former US Chief Technology Officer, will now give a short evidence session. Thank you. We'll start this final part of our session this afternoon. Ashkan, perhaps you could, I know that you were, I believe, monitoring the session we had this morning with Facebook. Obviously, the work of the FTC in the FTC report in 2011 was something we asked a number of questions about. And perhaps you could just share with the committee your thoughts and insights on the evidence session you heard this morning, and whether Facebook's interpretation of the FTC's ruling and how it's tried to comply with it, how that sits with your own views on this matter.
Absolutely. Thank you. And thank you for having me. Just a quick background. I was a primary technologist at the Federal Trade Commission that worked on the Facebook investigation in 2011, or 10 in 2011, and I was later the chief technologist at the FTC in 2014. I also worked briefly at the last White House, the Obama White House, Office of Science and Technology Policy, and most recently helped write the California consumer privacy law that just passed in June. My opinions here are completely solely my own, and given the nature of the FTC investigation, they'll be based on only publicly available information. I also want to apologize for my attire. I wasn't planning to testify today, so I didn't bring any clothes. I'm just borrowing a.
You should have come to our live music hearings. That was a different order.
I had a hoodie, but I fortunately got a blazer. Mostly I just want to make 3 quick comments based on the comments from this morning related to what I've observed in my work, both as an independent researcher and from what's public in the FTC settlement. So at the very beginning of the hearing, around 11 minutes in, Mr. Allen corrected one of the comments from you all about specifically that apps in version 1 of the API didn't have unfiltered access to personal information. And in fact, this is false. In the 2011 FTC settlement, the FTC alleged that if a user had an app installed, it had access to nearly all of the user's profile information, even if that information was set to private, right? So there's some, I think, sleight of hand with regards to V1, but this was kind of early V1, and this was only, I believe, addressed after the settlement. Additionally, in the same complaint, the FTC found that Facebook misrepresented their claims regarding their app oversight program. Specifically, Facebook's verified apps program, which was a detailed review designed to offer extra assurances to help users identify applications they can trust. The FTC found that that review was actually non-existent, and the company was not doing anything to oversee those apps. And again, that's in the complaint. Additionally, there were some statements made that apps would only have access to information if a user installed and consented to that access. I hope the New York Times, in their investigation and verification of the whitelisted apps program, and I have some tweets to this regard that show the screenshots of this access. Specifically, apps were able to circumvent users' privacy settings or platform settings and access friends' information as well as users' information, such as birthday, political affiliation, even when the user disabled the platform, right? So these were the pre-installed apps. Additionally, the Facebook, through a program called Instant Personalization, some apps such as Yelp and Rotten Tomatoes would automatically get access to users' personal information even without a user installing it. So simply by being a Facebook user and visiting the Yelp website, Facebook would transmit to Yelp your hometown, your location, your preferences, etc. So those are some discrepancies. I think the timelines vary, but this, in my opinion, was V1 if they're considering the changes in 2014 as V2. In short, I found that time and time again, Facebook allows developers to access personal information of users and their friends in contrast to the privacy settings and their policy statements. This architecture means that if a bad actor gets a hold of these tokens, such as in the case of Pinterest, there's very little a user can do to prevent their information from being accessed. Facebook prioritizes these developers over their users. And I think it was best laid out in Mr. Allen's win-win-win comments that the platform enables things we're not going to do and they're going to do, right? Facebook gets more engagement from the platform. Facebook users do things that Facebook doesn't normally provide, and developers get access to a large consumer base, right? Another way to describe this is Facebook pays app developers to build apps for them using personal information of their users, right? So if you think of if I'm a company and I want to have an app like Farmville or a third-party BlackBerry client written for me, I would have to pay hundreds of thousands of dollars in development time to have that app built. But Facebook says instead, developers, please come and spend your engineering hours and time in exchange for access to user data. And I think that kind of summarizes the core issue. Additionally, from my experience, I don't think Facebook is able to govern itself in this area. From my kind of observations of public data as well as my conversations with multiple stakeholders inside the company, my understanding is that senior leadership simply does not prioritize these issues seriously, and they'll continue to do the bare minimum necessary to pass through the compliance regimes, but will absolutely continue to make these mistakes as their priority is monetization of user data. Thank you for your time and for having me here.
Right. Thank you very much for that statement. So you, from what you said, it sounds pretty clear that what Facebook said to the committee, what Richard Allen said to the committee is not was not true, that users had no real control at this time over how their data was being used, and even when they tried to enable their privacy settings to protect their data, developers were able to get around that without the user knowing.
Right.
Yeah.
And not even get around that. Developers just had access to it.
Yeah.
Right.
And from what you said, this is effectively a commercial decision by Facebook in its doing a deal with the developers in order to encourage them to build on the platform.
Correct.
Yeah. And actually, we want to bring Charlie Angus. You want to come in?
Well, thank you for this. I guess my concern is, because you said you're worried about their ability to self-police regarding these mistakes. This is a company that we've been told made $18 billion in the first quarter this year. This is a very, very focused, driven corporation. The fact that they are ignoring their obligations cannot be, to me, seen as mistakes anymore. The fact that their senior representative spoke to a parliamentary committee, which I do believe, the way we have it in Canada, when you speak to a committee, you're testifying as under oath.
Correct.
To misrepresent basic facts, to me, is a contempt of our legal parliamentary system, but it's also a question of, if we cannot trust them to follow the law, we have bigger issues. And I want to ask you, from your regulatory position, that we see in Canada a real unwillingness of Facebook to show up to talk to regulators, but an incredible willingness to go behind the scenes, to lobby, to hang out with ministers, to do all manner of favors to get a free pass on legislation. In your experience in the United States, it seems that Facebook spends an enormous amount of money lobbying legislators so that they don't actually have to talk to legislators about their legal obligations. How would you characterize the corporate culture of Facebook when it comes to the rule of law and the rule of obligations to the democratic jurisdictions that they work in?
I think your observations are exactly correct. In the lead up to passing of the California legislation, Facebook came out publicly in support of the California Consumer Privacy Act, but in fact was still behind the scenes lobbying against the law that passed. And we've seen this kind of time and time again. Currently, it's the first time I've seen in the US where the administration, Congress, and the companies are all aligned to pass federal privacy legislations. And primarily that's to essentially preempt the California law and potentially give them carve-outs from GDPR, because the kind of a conservative administration feels like it might be oppressive to business, and Facebook is very involved in that process, is my understanding.
Thank you.
Thank you. Ian Lucas.
When the Cambridge Analytica scandal, GSR, first broke, in 2018, the big part of it, we had a lot of publicity out there saying how dreadful it was, and Mark Zuckerberg appearing before a couple of committees anyway with sackcloth and ashes, saying how dreadful it was. And ever since then, on our committee, we've been trying to get to the bottom of this data transference issue. And the conclusion I've come to is that actually the transfer of data is the modus operandi for Facebook. That's actually, far from them thinking it's wrong, it's actually what they do. Is that accurate?
I think that's right. So the platform, as you describe it, is simply designed as an API for third parties, advertisers and app developers, to reach consumers and collect information from consumers, right? And so that two-way transfer of serving content and collecting information is the business model of platform. It's essentially the platform. And the reason why it's beneficial to say a web platform is that when you visit a website with your web browser, those companies still, you guys have, you have a strong cookie law, you know how that works. You're in fact more privacy protective in a web browser because your web browser only reveals certain categories of information that you explicitly disclose to the site, or things like IP address or the web page you came from, which is required. On the Facebook platform, app developers receive a great deal more information, right? Such as your friend graph, your hometown, information that that Facebook chose to make public. So count one of the FTC settlement, the complaint, was that Facebook, I believe it was count one, was that Facebook changed the rules in 2009. That information at that time, prior to those changes, information that was public only to Facebook. And that meant you needed to have a Facebook account to use the platform. They made those changes to make it public to any website, including platform apps, in order to, I believe, allow app developers to get more information and incentivize creation of apps on their platform.
So the exchange of information really within Facebook is not seen as wrong. It's what they do.
Absolutely. Yeah, and I think the wrong, I believe, I interpreted the statements about wrong where it went to the wrong actor, not that the transfer was wrong, right? I think the issue is, as we know, it's essentially like inviting a friend to a party and they bring all their friends, right? And you're not necessarily monitoring the door and you inevitably have a terrible party. I think that's essentially what they meant as wrong.
Thank you.
Thank you. Clive.
Yeah, I just wanted to clarify. You're saying that what Mr. Allen said to us in certain aspects was categorically wrong. Do you think he knew he was telling us the things that were incorrect?
So I think the issue is that it's a very nuanced technical issue. And so if you describe V1 of the API as something from, say, 2012, after the Facebook settlement, to 2014, and you exclude whitelisted apps and instant personalization, then his statements are generally true, right? But if you include all the carve-outs, and we know the carve-outs to be significant, right? We know the carve-outs with the whitelisted apps to be significant. We know the carve-outs to API access to be significant. Then it was deceitful, right? It was in fact misrepresenting what the platform can do. As recently as June of 2018, June of this year, using the BlackBerry token that the New York Times was testing with, that was provided to me, I was able to access user data in lieu of a user's platform settings, right? So that was as recently as this year, right? These problems existed, right? Again, the description there was it was either for a whitelisted partner or a soft landing, is I believe the term they wanted to use for the API transition. So there was all these caveats, right? And so the question is, do the exceptions swallow the rule? And I think it's false to make statements that categorically this information isn't available when in fact it is.
So, I mean, because he's a member of this Parliament. I mean, he's a member of the House of Lords, and it's quite a thing if he's come here knowingly misinformed this committee. I mean, are you saying it's possible that he might not have known what he was saying, or
right,
but should have done if he was coming in front of this committee?
Right, or it's possible that he was trying to generalize and not be specific of all the kind of edge cases and exceptions that are present on the platform, right?
Thank you.
Thank you. Nathan.
I just want to start, you mentioned Facebook will do the bare minimum. You know, we were in Washington in October of last year, and we asked Facebook as part of our study on commercial sector privacy legislation, and we were looking for recommendations, and we said, well, would you propose additional rules, and are you open to a new regulation? And they indicated the answer was no. And then today they're saying, oh, we're open to regulation and we want more regulation. We want you to regulate us, and wouldn't that be great? So it's funny how quickly the tune changes once their bottom line is threatened. I just want to be clear about specifically Ms. Stevens was asking questions to Mr. Allen, and her concern, as I understood it, was if I use an application, my friend's information is shared regardless of their privacy settings. And Mr. Allen said, no, that's not the case. They could go in and they could check a box that said right. And are you saying that there's confusion there, that was not the case?
There was also confusion there. So the whitelisted app story that the New York Times ran in June, the story about BlackBerry, in that case, those apps, for example, would have access to friends' information. I actually tweeted a screenshot.
Regardless of what anyone clicked.
Regardless of if you explicitly went to the platform settings and said, "Do not share my platform," and then additionally in the testing for the findings of the FTC in 2012 and 2010 to 2012, FTC found that if you, for example, marked individual status updates as private, right, those status updates were shared with apps, right, or if you marked individual profile elements as private, those were also shared with apps.
So the notices they were sending to Canadians, at least, and maybe others with respect to the Cambridge Analytica information, was that even private messages may have been shared. We didn't get any confirmation from Facebook Canada to the extent of that. Their notice was may have been, which was striking as well. So the FTC, you were there at the FTC during the investigation of Facebook. And was there any indication at the time or any? So I'm less familiar with the FTC consent or the Facebook consent decree, but the extensive and unrestricted or fairly unrestricted, I would say, sharing of friend data with developers and app developers, was that part of the settlement in any way? Was that flagged for them at the time by the FTC? Was that a concern of the FTC?
So the complaint alleged misrepresentation of what what Facebook stated in their privacy policy, as well as what the platform privacy controls would do, right? That it wasn't specific to friends' information at that time. It was just all information, including friends' information. In 2014 or 2013 or 2014. Facebook, I think, with a blog post from Zuck himself, stated that your information will not be accessible to apps your friends install, and that was in 2014. They made a statement on their blog, and then they updated their privacy policy. But based on the New York Times reporting and based on my testing, that was still accessible to certain apps, at least the whitelisted apps that we tested.
Right. Okay. Thank you.
Thank you. Paul Farrelly.
Mr. Soltani, I wasn't expecting you to be here, so you clearly weren't. Said you weren't expecting that. So it's. What I'm just curious about is what's prompted you to sit in front of all people here.
Just to be clear, that he's walked in freely off the street. We haven't
pounced on him
or anything like that.
What's prompted you to come and sit on your own in front of everyone here to give evidence about Facebook?
So I've been in.
What are your core concerns?
Yeah. So I've worked on. So I was also the primary researcher for the What They Know series, the Wall Street Journal privacy series. I worked on this issue for the last decade, highlighting kind of the contrast between statements the companies make and their actual practices. That was my graduate research was essentially this, highlighting these differences. And I've been working to help structure and pass privacy legislation to address this concern. And so when I was literally just listening to the hearing this morning, and it's the same thing I did for the congressional hearings in the US, when companies make technically nuanced and perhaps deceitful statements, it kind of gets under my skin. Right. So my role is primarily as a technologist, right? So a lot of what I do is try to understand technical issues and explain them to policymakers and journalists. And time again, I think companies can exploit these nuances in very technical, and this is an incredibly technically adept committee, but I think companies still are able to exploit nuances and understanding and make these statements. And with the exception of actual audit and investigation, there's very little that you all and the public can do to challenge these statements. And so that's basically why I came. So on these specific issues, I've actually physically tested them myself, or digitally tested them myself, and so I know them to be true.
When you use the word deceitful, then we've seen some documents. We've had much toing and froing between ourselves and Facebook, and from what we've seen, you could use the word intrusive to describe the company. You could use the word rapacious, amoral, sometimes cavalier, contemptuous. How would you best describe the culture at Facebook as you found it?
I think I think it's best encapsulated by Mr. Zuckerberg's first appearance in the U.S. Senate and then later the House. The Senate hearing where he testified most recently, it almost seemed like a game of tennis, right? Of like, you ask me a question and I'm going to answer you in a way that you can't challenge, and I'm going to win that volley. And that's essentially that contemptuousness, that ability to like feel like the company knows more than all of you and all of the policymakers. I think most recently, if you might have seen this announcement that Facebook's going to create a Supreme Court to deal with fake news, like the level of confidence one must have to say that the statement was, I've studied this issue for 2 years and I feel now qualified to create a Supreme Court to deal with fake news issues. And on one hand, it speaks to the power of Facebook as a platform, and on the other hand, it speaks to the contempt that I think the company, at least the senior leadership of the company, has for an existing democratic process and multiple regulatory frameworks.
And do you think it's grown too big to care? It's so set in its ways. Why should it change? Because it's been phenomenally successful. And the answer, if not engaging in a tennis match, is simply to send in expensive lawyers.
Yeah, and I think they'll do, if there are laws not mandated, right, I think they will comply with those laws. I think they have a lot of influence, both politically and economically, right? In the U.S., a lot of the reticence to pass strong policy has been about killing the golden goose, right? So it's a leading sector in the U.S. economy, and there's a lot of worry that regulation will hamper it, right? And I think that's somewhat short-sighted. For me, the policy debate is similar to the environmental policy debate of 50 years ago, where there was worry to kind of clamp down on companies for emissions and for environmental harms, and we found that actually by doing so, we incentivized a great deal of innovation in that space, innovation around solar energy, innovation around renewable fuels. I think the same is true in this industry. I think smart legislation will incentivize innovation in encryption, innovation in privacy protective technologies that allow us to use these services but not suffer harms, not just from the companies themselves, but also from breach and bad actors, right? I've been trying to promote this idea of, folks are familiar with usability testing is a common term in this space. Usability testing is to platforms employ usability testing to see how their platforms are used. I've been trying to promote this idea of abusability testing, right? Platforms invest resources into seeing how their platforms can be abused to harm consumers. And I think smart policy would incentivize that kind of investment, as we've seen that incentivizing in the last 10 years around cybersecurity.
Richard Allen, who came before us this morning, is a former MP. I've not met anyone who dislikes him. I like him. He's the likeable face of Facebook. His successor as the Member of Parliament for Sheffield Hallam, Nick Clegg, is just about to move to California. Was an MP and then became the Deputy Prime Minister. They bought a former Deputy Prime Minister of the United Kingdom. So I just wonder what that says about Facebook.
In the US as well.
And Nick Clegg.
Do you think it's... can you see whether it's changed, after all the recent scandals, whether it's really changed its ways? Any evidence?
I think there's some evidence that the company is investing in the area. It's not clear whether they're investing enough, and they're clearly investing on the lobbying and policy side. But I think it speaks to, I think a good data point, particularly around the fake news issue, is the kind of issues and stories surrounding Alex Stamos, the former CISO's departure, right? And to understand what the company culture with Ms. Sandberg and with Mr. Zuckerberg versus, say, the security team, right? And I think it's almost, I think it's problematic to treat it as a monolithic organization. So my understanding, for example, is that there are parts and stakeholders at the company, currently, presently, and former stakeholders that were very invested in these issues. And in fact, the only reason we know about the fake news issues and the tampering was because of the security and trust and safety teams that essentially, contrary to the senior leadership's will, publicized some hints of this very early on. Right, and so I think there are people at the company that care about these issues, and there's some investment. But I think the fact that Alex Stamos just left or was kind of pushed out speaks to what their priorities are, and they currently don't have a chief information security officer.
Okay.
Right.
My final question is: I asked Richard Allen earlier on to what extent he believed that Facebook had complied with the FTC orders, and he said, to his knowledge, paraphrasing, fully. Is that your view? But the FTC is now looking again.
Well, the question was whether
they complied with the orders given to them by the FTC.
Have they complied, or are they in violation of
either?
So my personal opinion is that they are in violation of the consent decree. Again, that's my personal opinion, and the FTC has publicly confirmed that they're investigating the company. Now, the thing to remember about U.S. regulatory regimes, particularly under privacy, is it's essentially the two hooks are unfair or deceptive, and unfairness is a difficult hurdle usually for privacy-related issues. So primarily comes down to whether the agency thinks the company made deceptive statements, right, that were in violation of the consent decree with regards to their practices. And I'm hopeful that around these whitelisted apps, around the oversight of apps, particularly the monitoring of API and the knowledge they had regarding what app tokens and app developers were accessing the API, I think that we'll find that was negligent, or the agency will find that was negligent. But again, it's purely that the company made statements that they were doing this, right? The more, essentially the US regime, the more a company says that they take privacy seriously and they take steps to protect privacy, the more the FTC has hooks. If a company says we do our best and we really don't do much, the FTC really doesn't have a lot of hooks with regards to going after them. It's a little bit different. It's a market policy solution.
So just in conclusion, the email evidence that we have and that's also lodged and sealed in the court may be highly relevant to FTC inquiries.
I think that would be critical, particularly if there's senior leadership that were aware of these issues and chose not to prioritize those issues. I think that would be very telling.
Thank you.
Thank you. Joe Stevens.
Go back to Richard Allen's evidence and my question to him this morning, because I was very specific in asking if I had set privacy controls, Facebook could override them, and I didn't know about that in terms of allowing access to my information through apps and friends, etc. So what I'm interested in is, from what you've said in your evidence just now, how long a period would that overriding have been happening? How far back and until how recently? So in the kind of worst case scenario.
Right. So the kind of the period. So there's multiple privacy controls on the platform. There's individual profile elements and status updates have individual privacy controls, and then you have a kind of global platform privacy control where you can turn off app access. So in the 2009 to 2012 period, I don't believe platform controls existed at that time point, and the per status update or per profile element privacy controls did not do anything for apps. So if you set a status update to private, an app that you installed would have access to that information, even if it was set to private. I believe subsequent to the FTC order, the company began adding platform controls, as well as making sure that if you set a profile status update to private, an app wouldn't have access to it. However, certain whitelisted apps and apps like instant personalization still had access to those in lieu of those settings, right? So, and that was after 2012. And then from the kind of testing that I did most recently in 2018, whitelisted apps the apps we tested for were BlackBerry at the time, but I believe there's other apps that will be kind of highlighted, had access to consumers' information even if they had platform settings turned to off. And they had access to friends' information as well. So timeline-wise, 2014 is when Mr. Zuckerberg announced that apps would no longer have access to your friends' information, and there was a grace period of, I think, a year that they allowed that setting, and then they also gave certain apps even a small grace period, and then they allowed whitelisted apps to completely override that setting altogether. Right?
So we're effectively talking about, in the case of whitelisted apps, potentially 9 years, nearly a decade,
right,
where they have been able to access
friends' information.
That's overriding your privacy.
I believe
settings.
so. Yes.
Right.
Yep.
So that effectively is not accidental. That is privacy violation by design, isn't it?
I think so, right? And the argument that I've heard the company make is that we're allowing app developers to develop apps for us that that we wouldn't otherwise make. So the statement I've heard is that we wouldn't build a BlackBerry app. We're not going to invest the resources. There's just not enough BlackBerry users. Sorry, Canada. So we're going to instead let the platform essentially have administrative access to user information like they were us, and thereby override user settings.
Okay, thank you. That's really helpful.
Brendan O'Hara.
Thank you, Chair. There's enormous frustration, I think, around this table at what we heard this morning. This is certainly for the UK's committee. It's our third attempt to speak to Facebook about this. What do you think, from your viewing of it this morning, what did Facebook want to get out of today?
I think, if I had to summarize, it seemed like hopefully appease you all and not have to call Mr. Zuckerberg to testify.
And do you think if you were Mr. Zuckerberg having tuned in, you'd be quite happy with what was achieved today?
I think so. I think they were the tone was, this is what we do, right? The statement about win-win-win. I think a lot of that, the undertone of that was that this is our business model, right? This is our essentially the exchange of personal information and the use of our platform by third parties is by design, and this is kind of how we make money. It's kind of, again, to the earlier question of how I would describe it, there was a question in the Senate hearings in the U.S. where Mr. Zuckerberg responded, "Senator, we sell ads." Some of you might remember this quote about how they make money, right? They're like, you give your product away for free, how do you make money? Zuckerberg responded, "Senator, we sell ads." I think the tone was similar, of like, you all need to understand that this platform is monetized by the exchange of personal information, and that's how the platform works, and that's how it's going to work, right? And I think that was the message, the undertone of Mr. Allen's comments today.
And therefore, any change to that model of how the business works will be fiercely resisted.
I mean, he also said that this morning, where he said, we will follow the rules as you pass them, if you pass new laws, but he raised his hands and said, but it's going to have, it's going to have consequences, right? And that was almost, I thought, and again, you might hurt the golden goose, right? There's a lot of money in this ecosystem. And so I think that was kind of a warning.
So would it be fair to say, do you think that Richard Allen was the right person for Facebook to have sent here?
I think so, yeah. I mean,
from their perspective.
Of course, you all know him. You all trust him, right?
I think you'll stick with the first statement.
Trusted him, right? I mean, if it were me, I'm not sure. So from my understanding of the company, if I were to invite one person, it would be Ms. Sandberg, right? My understanding for a lot of these decisions are hers, right? She is the one who makes the monetization calls, that makes the priorities, and that's who I would want to see kind of up here testifying on these business decisions, specifically on the monetizations and the decisions of what to prioritize.
It seems to be that over the months that we've been investigating and speaking directly to Facebook representatives, that everyone knows a bit. most folk know enough to get by without ever being able to implicate the boss or their company. So is there an individual at Facebook who knows everything?
Right, probably not. Right. One of the comments I made earlier regarding whether, so one of the reasons I don't believe the company is able to regulate itself is that for a lot of this period in 2010 to 2016, maybe 2015, the motto was move fast and break things, right? And so from the technical implementations that I saw regarding, for example, the whitelisted partners, the whitelisted apps, they were incredibly hacky, they were incredibly thrown together, very haphazardly, right? If it seemed as if a business development person and an engineer implemented a feature quickly. For example, in order to whitelist an app, all they did is say it was pre-installed for all users, right? That was the workaround instead of creating a new kind of oversight regime or a new API specifically for those apps. They essentially just added a flag to the database that said it's a pre-installed app, so it gets permissions by default. So it can kind of skip over the consent process. That's very hacky. That's very not straightforward, and I think that makes it very hard to regulate. It makes it hard internally to oversee, right? And I think as a result, there's engineers just kind of running in the direction set for them that the kind of leadership has set. And I'm not sure that leadership is giving guidance to say, no, you know what, this is a priority, user privacy is a priority, or data use is a priority.
So it's almost like an internal Wild West at Facebook.
I think up until 2015, 2016 it was, right? There's really early news stories about how interns they would do these hackathons, which are like these coding sprints, programming sprints that someone could come in and program for an extended length of time. And there was news stories about how an intern could come in for a summer hackathon, and make changes to the live platform, right? And at that time, the platform was only hundreds of millions of users. It wasn't, billions of users. But to think about just a user without oversight, without change control, without kind of governance, to just make a change to a code that affects millions of people, right? I think that speaks to the culture that was present at the time. And I think that's probably changing, right, given all the pressure, but I think it's important to note that the roots of the company as the Wild Wild West.
So given that there are representatives of 400 million people sitting around this table, where should we be looking for the unambiguous truth about what Facebook are doing and how they're doing it and how they plan to proceed in the future?
I mean, I think so. At least in the UK, you guys are in Europe. I think you have audit rights. The DPAs can do audits of companies. And again, I've worked as a technologist who's for that period of time seen a great portion of the source code of the company and how the company operates. And even at that time, when it was a tenth of the complexity it is today, it's incredibly difficult to discern how the company is operating. But at least you have the ability to go in and challenge the company as you've done before. I think that the key is to have a compliance regime that has requirements of the company that is verified externally, right? So one of the other recent news stories has been around the oversight regime that the company employs. Is employed by, they essentially, the FTC consent decree requires that the company hire auditors that they pay for, that then does privacy assessments that are self-attested, that then the company signs off on. And I think having kind of an auditor that you pay and that lives in-house with you and that you control is not a sufficient audit scheme. So having a DPA and having the company essentially make attestations and demonstrate to the DPAs that they are in compliance to whatever regime you set, I think is perhaps something you might consider. And that's what we do with utilities over time, right? That's what we do with any large institution, right? We have safety, so airlines, right? We have safety standards that they have to meet, and then they have to demonstrate with an outside auditor.
Yes, thank you.
Thank you. Charlie Angus.
I really thank you for this, and I'm maybe going off form here in the committee, but I think I'll ask my question to the chair. as a guest. I've been a member of Parliament for 15 years. I've been in all manner of committee hearings. I've seen positive, I've seen negative, I've seen reluctant. I have never been in a set of hearings where getting basic answers from people who know better has been so difficult. I've never been in committee hearings where people have had to watch testimony and give us live messages saying they're not telling you the truth. I find that very concerning, and part of my concern is that they know we're generalists. My main job as a member of Parliament is getting Mrs. O'Grady's heat turned back on in her flat in the winter. If I do that, then I've done my job. And so we have to ask extremely precise questions, but the more precise questions we ask, the further away we get from the source, because we get dragged down further and further down the well. So I put it to you, Chair, that Facebook sent someone very knowledgeable to everyone around this room. I didn't know who Mr. Allen was. I didn't know that he was a British parliamentarian. But the words that we're dealing with were always on their turf. But they today sent someone on our turf, which is the turf of Parliament. And when I see our witness use the word contempt and deceitful, I find that very, very disturbing. So I would put it to you, Chair, as I would if we were in the Canadian Parliament, that if Mr. Allen misrepresented facts, and I'm not all that concerned about whether it was this point of a detail or that point of a detail, but given the gravity of the situation, given the extraordinary efforts of legislators from around the world who came here, that if we were misled, and perhaps Mr. Soltani could give us the specifics on that they're now on our turf, and if they're showing contempt and deceit to our parliaments, that is worth considering and making a finding. And so I would put that to you, Chair.
Yeah, well, no, that's duly noted. I think we've recorded what was said. I think, based certainly on the evidence we've just heard, that we're in a position to follow up on that, back to Facebook to ask them to explain the discrepancies between the evidence that we've heard, and I think we could certainly take that further with regard to Richard Allen's evidence and the misleading nature of some of the answers that he's given. But it also underlines how important it is for us to gain access to written documents and materials from within the company as well, because then we've got the unambiguous truth, which is why we went to such lengths last week to try and secure these documents, because I think that gives you, I must admit, the picture that paints is much closer to what Mr. Soltani has told us than it was to what Richard Allen had to say this morning.
Thank you.
Sorry, did you want to comment?
Okay, just one quick comment. So I think that's a very astute observation, but one of the challenges in this space with regards to, say, our terms and their terms is that we now have terms that didn't exist before, status updates and apps and APIs, right? And so I think the difficulty exists in this, because it's so technical and it's so nuanced, that the difficulty in making things crystal clear, and remember, it's not like a life cycle of a software is fixed in time now, right? Code is constantly updated. So to say what your app was doing yesterday, there was probably 3 different code updates yesterday. So over the course of the day, it might have done 3 different things, right? So I think part of the key here is, in addition to discovery and having a great deal of documents and auditing, is to have technical resources on hand to you all, and I'm sure you do already, but having more technologists, and I'm biased, I'm a technologist, but having those technologists that can sit with you and analyze those documents and ask those questions directly, right? So prior to 2010, the FTC didn't have technologists. They would hire experts when a case went to court, but for most matters, they didn't have in-house technologists, and they brought on technologists like myself to help them investigate these matters. And I think Congress in the U.S. now has a technical fellow program, and I think that's critical for making sure that when these answers are answered precisely, then you can get into the technical realm and ask very specific questions that only have one right answer that they can demonstrate through an API documentation, for example.
Thank you.
But then I think I agree with all of that, but I think part of the problem is they deliberately send witnesses who are not technically capable of answering those questions and have got plausible deniability, and we've seen that time and again throughout this inquiry, where the Facebook witness has just not told the truth, and then we're told later that they weren't cited on the evidence that they needed to do that.
Yeah. Thank you.
I think Giles Watling next.
Yeah, just very quickly, I'm going back over something Mr. O'Hara was touching on earlier. I'm interested in the governance side of this, looking from the outside, and I'm going out of specifics here, but it strikes me that this thing has kind of run away. It looks like a feudal autocracy. And that no one man can control it, so therefore us trying to nail down one guy is kind of meaningless because it's just grown and grown and grown. Would that be an accurate assessment of the situation?
I mean, I think there are unilateral decisions on the platform that have been made, right? So there was, not fully implemented, but there was, for example, a unilateral decision around data brokers, where one guy decided, or maybe the policy team decided that, data purchased from data brokers or data sent to data brokers doesn't meld with the platform's vision, right? And that was partially a business decision and partially, I think, an optics and policy decision. So yes, it's grown quite huge, but there's still, the majority of shares is maintained by one guy, and the policy team still is able to make unilateral decisions as long as those decisions are maintained within the bottom line of the company. Right, or falling within the bottom line of the way the company monitors.
So in your considered opinion, Mr. Soltani, we are chasing the right guy here?
I think, if it were me, I would probably bring Sheryl Sandberg, and I would probably see if we probably wouldn't be able to get him, but one of the two former CTOs, right? So I would get, Alex Stamos or Joe Sullivan up here, and they're going to be, locked down with lawyers, but they know the technical side of things very well, and I think the business decisions made by Sheryl, I think those would help. So maybe three guys,
that's really interesting.
Three guys and a woman. Right?
Interesting to know. Thank you for those names. That helps hugely. With your background of privacy and ID, do you think there's another one coming up? Do you think there's another big breach of data privacy coming up that we need to be looking at?
Inevitably, right? So the question is always, when is the next Exxon Valdez that's large enough to cause, a response? And we still haven't seen one, right? So even the last Facebook breach with the token breach, where you could actually access users' profiles using this token, that wasn't a Cambridge Analytica type breach. That was an actual full website breach that was exploited and knowingly exploited. That still hasn't seemed to be enough to tip the scales. And at some point I expect either it's seeming like it's becoming the status quo, which is really sad, or hopefully there's going to be one that finally causes people to act. And most likely, if I had to venture a guess, in the U.S., do you guys know the video privacy law in the U.S.? So the VPPA was brought about since members of Congress had their information affected, right? So I think when your information, when there's a privacy scandal in one of the regulatory agencies or one of the kind of oversight bodies, I think that's when maybe we'll see a response. But there hasn't been one large enough yet, I think, to have anyone act, in my opinion, over the last 12 years. And I think in the U.S., we'll probably get a privacy law probably in the next Congress, is my guess, and it'll be some combination of an Honest Ads Act and some sort of light consent privacy law that preempts the state laws because of the pressure, and it will be actually a lighter touch law than the California law.
So in the meantime, you think it would be pretty much a case of caveat emptor?
I think so, yeah.
Okay, thank you, Mr. Soltani, for being a surprise guest at the party.
Thank you. Rebecca Powell.
Thank you very much, Chair. Just a very small question that touches on something that my colleague from Singapore mentioned this morning. Lord Allen mentioned that, he just said, admitted openly that Facebook had made mistakes. He was quite open about that, particularly in taking down hate mail. But he was still convinced that Facebook were the right body to be in charge of taking down hate crimes. And I wonder what your views were on that.
I think it's incredibly challenging, right? So one of the questions is around business models, right? And I think the business models have two components, right? So the business model is to monetize data, as we've discussed here, but the company line is to connect people, right? So Facebook's mission is to connect people. And one question is, should we be that connected, right? So there's a great deal of tolerance in the world because there's kind of practical obscurity, right? You and I might have very differing views, but I'm not exposed to all of your views, and so therefore I might not have an opinion on all your views, nor do I feel like I need to kind of impose mine on yours. But I think this actively connecting people for the purpose of driving engagement, right? And what drives more engagement than kind of controversial content, right? This business model of connecting people and driving engagement for controversial content, I think, has caused a lot of contention on the platform, and I think that's something we should question. So technically the person to best filter that content is the platform, I think, but I'm not sure the policy decisions on how to filter content should be made by the platform, since the incentives of the platform are to drive engagement and to connect people that would otherwise not be connected. Right?
You could semi-solve their problems by them employing a great many more people looking for this.
No, but I think articulation of the policy is critical, right? And so rather than selective enforcement of policy, articulating what specific policies and what constitutes. So like the big thing in the U.S. is around the Honest Ads Act, and it was discussed in this committee as well, regarding political advertising having to register and disclose that they're political advertising, and then having some transparency around that political advertising. But then the question becomes, what is political advertising? Issue-based ads, for example, if you advertise about a women's issue or a health issue, that becomes non-political, that becomes an issue and not necessarily subject. So I think having, as most of society has functioned till now, some kind of democratically elected body decide what the policies should be and then have a company follow those policies seems like maybe the smart idea to me.
Thank you.
That's it, thanks.
Yeah, Ian Lucas.
Can I ask you about the FTC? You worked for the FTC. There was some questioning in Congress, in the Senate, about the FTC and the GSR breach, which I'd like to ask you about. I don't know if you may have heard me discussing with the Information Commissioner the reporting of data breaches. Now, in the UK at that time, there was no requirement for the data breach to be reported to the Information Commissioner. What was the legal position in the United States?
I don't believe there's a federal data breach reporting requirement, but California has a data breach reporting requirement. And so it has a particular standard for what constitutes a data breach, but California law requires that companies disclose data breaches.
So there was an interesting question by Senator Nelson to Mark Zuckerberg, because he actually appeared before the Senate. Did anybody notify the FTC? And Mark Zuckerberg said in response, no, Senator, for the same reason, we considered it a closed case. So it appears that the issue in the mind of the Senator arose there. You don't know whether there was there wasn't a federal requirement. But
I don't believe there was.
Okay.
Right.
Now, you also have heard me ask about the date of the knowledge of Facebook on the breach. And we're going to get clarification from the Information Commissioner about that. Now, Mr. Zuckerberg, on a number of occasions, said to the Senate that that Facebook became aware of the breach in 2015 as a result, I think, of a Guardian article. Now, we are looking at the issue of whether Facebook may in fact have heard about that earlier. Now, bearing in mind the seriousness of the breach, if Facebook were aware of the breach at an earlier time, what would be the appropriate step to take in those circumstances for the company?
I mean, I think so I testified to the hearing with Alexander Kogan, the kind of developer, and the response was that, and Mr. Zuckerberg's response has been that they kind of sent their lawyers to essentially convince the company to to delete all copies of the data and not share that information.
This was in 2018?
This was,
I believe,
or maybe 2017.
Yes.
Yeah, that's right. So that's their kind of, I think that's their response to
but in 2015,
right,
they say that they didn't take any action because they considered it a closed case.
issue, right.
But what would have been the right approach for Facebook to have taken when they were notified of the data breach? What would be, within that business, what would have been the appropriate step?
I think so typically with a data breach, you notify the affected customers, you try to ensure an audit deletion of those records, and you look at the downstream dissemination of that information, right? So they would have probably looked to see how that information was used. I believe they didn't consider the first and latter step. There was no notification and there was no downstream investigation. There was simply a request by the accessing party to delete that information and sign a contractual requirement.
And that step appears to have been in response to the publicity.
That's right.
So there's no evidence of Facebook actually taking any action until there was publicity concerning.
That's right. And I think the thing to note, though, is that from the early comments and the early responses by the company, I don't think the company considered it a breach, right? They considered a developer that had valid access to the API violating the terms of use of that data, right? And they didn't consider that a data breach. They considered a terms of use violation that they investigated, right? And so there's a different terminology and a different mindset. Again, back to the earlier point where the ecosystem is about the exchange of data. So the flow of data in and of itself is not problematic. The use outside of the terms of use is problematic. And we've seen this in multiple examples of the company. So there was an early case in 2010, I believe, where the company sued another company, Power Ventures, for scraping users' information and using it. And that was a competitive issue. They didn't want this other company to have users' information outside of their platform and their control, right? So they take action and they monitor the platform for abuse when it has a strong business interest. But I don't think necessarily when it's in line with the business interest, it becomes a problem.
Thank you very much. Just one final point. Mark Zuckerberg repeatedly told the Senate that this breach took place in 2015. I think that was in December 2015. So if it took place in 2014, he would have lied to the Senate.
Paul Farragut. Just going back to previous evidence, Dr. Kogan actually, to paraphrase him, told us that he didn't consider that Facebook had any terms and conditions because it never enforced them. So it didn't cross his mind.
That's right.
From this morning, we were talking just about the overall tenor, or let me use a Californian word, vibe, that I got from this morning was we're a social site, so whether you're a developer or a user, it can't be one-way traffic. You've got to give something back to the community, and that means all the personal data that you've got, regardless of whether you're paying to run ads or you're the eyeballs that are there to enable us to sell ads. And that seemed to be, that's the way we do business. And that's part of the deal. That was the sort of impression I got from his evidence.
Right. I mean, I think the hard truth is, on one hand, it's a free service, and the comment is, the service is free for users, right? Senator, we sell ads, right? It's a free service. There's not any anti-competition issues because it's free. We can't, you don't need to regulate it. There's no cost. It's free. So that's the kind of, on one hand, that's the line. On the other hand, there's this assumption that people understand it's a tit-for-tat exchange of personal information. And I'm not sure it can be both, right? It's either free or there's an exchange of information that's non-monetary. It's an exchange of personal information that's given to the platform, mined, and then resold or reused to third-party developers to develop apps, and then to advertisers to advertise to, right? And it's one of those two things. So the California Privacy Act, one of the provisions, initially it was similar to GDPR in that if a user opted out from the sale or sharing of their information, companies were prohibited from denying them access to the site or service, right? So you could opt out but still use the service. When it went from a ballot initiative to a legislative to assembly bill, there were some compromises made, and one of the compromises was that companies could charge users that opt out for the service. However, the key, I think, provision there that helps is that companies can only charge users the value they extract from their information. So and it can't be usury or it can't be exploitative. So I think there it starts putting the onus on companies like Facebook to articulate what the value of personal information is to users. So you can have a free service like the Washington Post. You can have a free version if you let us track you, or you can pay $5 per month or $9 per month to use a service. And that articulation, I think, can solve this dilemma, which is that it's a free service, but wink, wink, we believe users understand that they're selling their information, and in fact, we're selling it to advertisers and app developers.
Yeah. Just the final question, just to pick up on your preview of, or look forward to an Honest Ads Act in the States. We've been looking at some political advertising, misinformation, manipulation, and the company said it's taking steps to drive that out. We'll see what happens. Our colleagues from Singapore this morning highlighted the unwillingness of Facebook to take down hate speech, which could have had appalling social effects in difficult times. And the answers that they, when that was reported, that came back from Facebook's automated platform, are very similar to reports I've made of ads that are fraudulent. And they come back and they say, while this ad doesn't breach our policy, how can it not? It's fraudulent. We understand you don't want to see this, and you won't see this, but lots of other people will still see it, of course. Right. And so you just wonder, actually, at the end of the day, with that attitude towards complaints, whether it really will take legal responsibility and liabilities, and a change in the law, therefore, to make Facebook pay more than lip service to complaints in different spheres.
So the two responses that kind of make me chuckle in this space. So I also worked on the White House Big Data report and the AI report for the last White House. The response to this is we're going to just create a list of kind of hate words that we censor for. Right, we're just going to create a list of words, and we're going to throw AI at the problem, and it's going to be solved. And if we know anything about adversarial attacks, so my background prior to the work was security and kind of anti-spam perimeter protection. Adversaries will always find ways to innovate, and you need a lot of human investment and control and collaborative filtering, which is what you're just describing, to make sure that input from people that have a problem with content is propagated so that other people don't see it. You need a lot more steps there than just paying lip service by creating a list of problematic words in whatever language and this vague notion of AI. I think the AI assumption is going to cause more problems than it will solve, actually.
Thank you.
Yeah.
Bob Zimmer.
I'll be brief. And it kind of came up to me as you kept talking that you're obviously an expert in the field. And one thing we've asked of different people in Canada or here is foreign influence in elections is, again, my big concern. How would you fix that? Because the easiest way that I see to tackle it, and it's not easy by any means, but I see it as the only way to really deal with the problem, is attach an ID to every individual, like in Estonia, essentially.
Right.
So if you're on a platform, it's clear that it's Bob Zimmer. I'm buying the ad to run in a campaign, or I'm the CEO, of company X. I'm buying the ad to run. So if I'm in Russia and I'm Yuri, I still show up on Facebook as I'm Yuri, buying an ad to run against Bob Zimmer in Canada. I see that as the only solution. But what is your suggestion?
So it's an incredibly difficult problem. I helped organize a workshop last year on this issue, invited all the platforms as well. And it's not just buying, right? So the social problem is, one, the propagation of kind of fake information, right? But two, the use of fake accounts to propagate opinions or real information that's biased, as well as the convincing of real users to propagate information. And the latter two wouldn't be solved by a real ID policy. And I have issues with, instead of essentially incentivizing companies whose business it is to know you, to then better know you by verifying your identification. right? So I think it's a double-edged sword to say we think fake news is a problem, advertisers. So make sure you get.
Is it something that we need to give? Like the classic example is that little blue check mark on Twitter or Facebook. Is it something that the government has to apply? Like we have
right, but
we
still,
have money that
right.
has certain things within it to keep it secure, so it can't be copied easily. Is that kind of something that the government needs to step in and be?
So I think identity verification is one proposed solution. I'm not a huge fan. I think anonymous and pseudonymous speech is actually important online. Yeah. I think the key is around engagement and business models, honestly. And there's different technical approaches. One of which I think is you could consider slow news, right? So the issue isn't with hateful speech or fake content on a small scale. I think it's when it reaches a large audience. And I think the issue the companies have had is that they say the volume of content created online is beyond which we could manually filter and curate, right? And so one response could be that you curate and filter only the trending articles, the ones reaching, so you slow things down. If you see things rapidly disseminating that are suspicious, you slow them down, and then you have a human verifier fact check. And then you have specific policies stated on and guidelines about how that fact checking and verification happens and how content gets filtered. You have transparency reports that speak to how that content was filtered and verified, and then you have a package, and it will still solve 90%. But again, we still get spam from time to time. We haven't filtered all spam, but we've done a good job at taking out the problematic spam. I think it's the same issue. And then there's a third piece, which I think not a lot of people are talking about, which is that there's the concern of external meddling and external influence by actors to meddle with elections. But the question of the platforms themselves being able to influence elections or influence outcomes is another one. And I don't want to sound like paranoid. I'm just like one observation, or one recent observation I made at a kind of Chatham House Rule conferences. One platform was using automated means to filter content, and as a result was filtering a disproportionate amount of conservative content. So there happened to be more conservative fake news ads. So their system was taking down that fake news ads. As a result, to not seem biased, they were then promoting more conservative content on their homepage, right? Independent of what the actual distribution of conservative versus liberal content was. And so I think that subtly influences outcomes, right? But there's no disclosure requirement, no requirement for companies to describe what their algorithmic biases are and how they promote content. And I think that's another piece of not just external, but the power the search engines and the news feeds have.
Thank you.
Thank you. Just a couple of questions for me just to finish off. We asked Richard Allen earlier about how the reciprocity policies work on Facebook. Typically, he was pretty vague about that. And from your work, work with the FTC and the White House, I mean, what insights do you have on that? I mean, to us, it seems like there's a basic deal with developers, which is you give us a user accessing Facebook or using particular apps from Facebook gives all their data in return. There's an exchange, there's a data exchange.
That's right, and I think it varies. Like, there were some comments today, the earlier hearing, about preferred partners, right? Certain ones that give you more value. And I think it's true that you're going to make certain concessions and certain considerations for companies that will drive either a larger amount of content to you, or you have some existing business relationship with. In the Valley, it's often, if your investor also invested in another set of companies, you often give those companies some preferred deals and partnerships, and often that involves access to user data.
Yeah. And so for companies that will, for whitelisted companies, effectively, whitelisted organisations on Facebook, is that based on that value exchange? So the more value you are to Facebook, the more likely you are to be whitelisted?
I believe so, yeah.
Yeah. Which is, and do you think that includes ad buying as well as data exchange?
I'm not sure if it includes value in so much as, I think to some degree, it's about engagement and users. I think the ultimate is how many users and how much engagement is this going to drive. The question of whether, so there was, in the New York Times reporting, there was certain large ad purchasers and automobile industry purchasers that were getting preferred access to the platform. And it wasn't clear whether that was because they were having large ad buys and they had a lot of money to throw to the platform, or they had a large large amount of kind of engagement and users they could drive to the platform. But at the end of the day, I think it's about relationships and influence, right? So, knowing someone that knows someone in this committee makes me more likely to be able to come here, right? And I think the same is true for the platform relationships. If my ad guy pays a lot of money to the Facebook sales guy, it's more likely that I'll get a meeting with the engineering team to create a custom API for my platform.
Yeah. So, but the exchange. I mean, the reason I think there's a value exchange of sorts, because what you're saying is companies that end up being whitelisted, having preferential access to data.
That's right.
They're either they're potentially giving Facebook a lot of money by buying a lot of ads, or they're giving them a lot of data because they're bringing a lot of users with them, which is a huge value to Facebook as well. Or they're doing both.
Right, or they're driving a lot of eyeballs, engagement.
Yeah. So there's a value to Facebook. There's a commercial value to Facebook of that relationship.
That's right.
And as a consequence of that commercial value, that third party gets preferential access to the site.
That's right. I mean, think like just from a simple, really basic numbers game. If you run a website and tomorrow decide you want to create a Facebook app, right? It's going to cost some amount of dollars, depending on the scale of your app. Say $100,000, $200,000. It's worth for you to invest that initial development resource, as well as the ongoing cost to maintain and host that service, to be on the platform, and so you do it. And so, at the very least, that development number is the initial investment, and that's the value exchange for the company.
So do you think what's happened then since 2014-15 is that if you're a big player, then actually what you've done is you've found the back door into the data. You bypass the systems, you get full privileged access to all the data because you're a big player. You've got bringing a lot of eyeballs, a lot of data to the party, and you're potentially spending a lot of money.
It's possible. Yeah.
If you're a relatively small developer, though, then you're going to get squeezed out of that market, aren't you?
That's right. You just follow the standard API. And you're restricted from access. That's right.
So, I mean, do you think there's a concern then that these changes in policy have been detrimental to lots of developers creating apps and tools that used to run on Facebook successfully, but were effectively pushed off the platform?
I mean, I think that's an important question. So we know that there was, for example, to the earlier question of friends of friends, or so my friends data, right? Friends of the users' data. There was the initial announcement, there was a kind of grace period, and then there was a selective grace period for a set number of companies that had rolling dates. And for some companies, it was never cut off. And the question is, how were those decisions made? It would be interesting, right? Was there a pattern in, for example, who the extension was given to, right? And most likely, if you're a small app developer, you're not going to get an extension. But if you're a significant player on the platform, either by the users or I think perhaps by your ad spend, you might get preferential access and the delay extended.
Yeah, but I think given the scale of the business, given that it has almost monopolistic powers as a social network, that would seem to be massively anti-competitive in a way. That it would be an abuse of power on their part to behave.
Yeah, I mean, yeah, absolutely. Yeah, and there's also, you guys haven't brought up the ONOVA, the VPN issue, but that's another area. Yeah.
And that's again where sort of another example of privileged access to user data without their consent.
That's right.
Yeah, another one.
Yeah.
I mean,
that's by Facebook though. So Facebook purchased a VPN provider, and they admitted, there was public statements, the fact that they monitored users' use of this VPN to see what apps users are popular with users in order to acquire those apps, right? Or to build a competitor.
Yeah. I mean, so many of these issues seem so important to the inquiry we've been running of user data still being acquired without user knowledge or consent on a big scale.
That's right.
And also this other issue now, which I think has come to our attention, of Facebook's aggressive policies being used to do deals with big commercial partners, people that are valuable to the company, and pushing off smaller developers with much poorer deals and no real opportunity to appeal that. And both those things seem to be, well, in terms of GDPR and data protection rules, question the legality of it, because it certainly doesn't pass the informed consent test. And you question the commercial practices and the impact that has on developers if an arbitrary decision is being made that favours them commercially. And I think these are important issues for us. And again, I think these are important issues behind the reasons why the 643 papers need to be in the public domain, because so that people can get a much better insight into some of these issues, and Facebook can respond to the specifics rather than our questions.
I think that's critical, particularly for other regulators as well.
Yeah. Thank you very much. It's been a great way to finish the session, and you've provided a lot of interesting light onto the fog of Facebook's evidence. Thank you.
Thank you so much for having me. I wasn't expecting.
Thank you. Thank you.